So folks, welcome to this third and final virtual session concluding DebtCon5. Now, DebtCon sounds suspiciously like DEFCON for those of you who are not following this enterprise. And I think it's fair to say that it's not, I don't think there's been a single DebtCon that for which that was an inaccurate association. So it has been a perennial emergency in sovereign debt world. But I would love to just take a couple of minutes to pull back and say a couple of words about this enterprise, and again, thank all of our participants and supporters. So DebtCon actually stands for Interdisciplinary Sovereign Debt Research and Management Conference. And if the acronym doesn't add up for you, you're not crazy. It's all actually part of an elaborate inside joke that's long lost on history, but the initials add up to SDRM, which is a sovereign bankruptcy proposal that was salient around 2001 to 2003, and that we've been talking about ever since. This is a series of conferences that we have roughly every year and a half, hopefully every year, that bring together, we hope, theory and practice, folks from different disciplines and different geographical areas, really to try to focus on a shared enterprise, which is the perennial challenge of sovereign debt management, sovereign debt crisis management, and sovereign debt restructuring. It's my special pleasure to be joining this session hosted by III, because, well, for a number of reasons, but III has been a partner in this DebtCon enterprise for the past 3 cycles, including through the incredibly wacky 2-week stretch of events that we had at the height of the pandemic. And again, here, III hosted the closing session, bringing together these various strands of law, policy, politics, history, and all manner of social science thinking. So now we remain committed to keeping this interdisciplinary, to bringing policymakers, academics, and market participants in the same space. And we're thrilled to be back in person as well as in virtual format. So this year we started in Colombia, actually in early May. That was the first virtual session. Then we had another virtual session in Morocco, focusing on the challenges of debt on the African continent and beyond. Then we had our first back to in-person conference hosted by the European University Institute just outside Florence, and this is it. This is the closing session of DebtCon5. Today we are going to bring together some very interesting and not always obvious threads, right? So we're not every paper, you might have noticed, has the word sovereign debt in the title. But we feel very strongly, and certainly, III and Ted Janger, who's been really the brain behind this particular operation, feel very strongly that the topics we're dealing with today, notably sub-sovereign debt, quasi-sovereign debt, kind of sort of sovereign debt. David, I'm pitching all of this to you because I really don't know how we describe Puerto Rico in this context, as well as the challenge of sovereign contingent liabilities that we see in the financial sector around the world, and that Winnie will be talking about later on, I think are absolutely central to the to thinking about both theorizing and finding practical solutions to the sovereign debt challenge. So at this point, just a few ground rules. If you have a question, please type it in the chat. Anna Gelpern, you can see my name and postage stamp on your screen. We'll make every effort to monitor the chat and give you the floor. And oh yeah, and one more housekeeping thing. This is being recorded. Those of you who joined after the recording announcement. So, and all of the chat questions are obviously seen by everybody. We are not sure when it's going to be posted, but it will be posted. Okay, so we are incredibly lucky to have with us today a DebtCon regular, Professor David Skeel, whose accomplishments are way too numerous to list, and so I will let you peruse them in the program. But really, David, you have been at the forefront of the debate about statutory and contractual approaches, public law and private law approaches to public debt challenges. And then, as if living the DebtCon mission, you participated, of course, in the Puerto Rico Recovery Board from the very beginning, I believe, right? So theory, practice, cutting edge, interdisciplinary, you name it, you have lived it. So we're thrilled to have you with us. David will have the floor, followed by Ted, and then I will comment and or just let y'all have at it. So thank you.
Thanks, Anna. It's always a joy to be part of DebtCon. It's one of the greatest things going, and the evidence that is in fact the case is whenever I'm tagged somehow in a DebtCon related tweet, there are more likes than anything else that I do. So there's clearly a large audience. And I'll also say, Anna, it's sort of your fault, along with a couple of others, that I am in this space. You were one of the people who pulled me in. There were two or three, you and two or three others. But it's an important space, and it's been a joy to be part of it, both as a scholar and in many respects to the extent the Puerto Rico work is analogous in some ways as somebody involved in it from the practical, in the middle of it side. So I'm going to try to go 20 to 30 minutes. We'll see how well I do on that. Let me try to pull up. I'll make my shot at pulling up my screen. If I can find it. Per usual, I can't see it. Yeah.
Have it on standby if you'd like.
Yeah, can one of y'all pull it out? I can never get the screen share to work. I don't ever see the option.
Can you see it?
Great. I can see it, and let's see can I move it, or do I have to ask you to move it?
You have to tell me to do it.
Sorry about that, Anna. So I'm going to talk about what I refer to as innovations in the Puerto Rico restructuring. And we can go to the next slide. Thanks, and sorry again. I should be doing that. Just a quick roadmap of what I'll be talking about. I want to do two things in the next 20 or 30 minutes. That is, give you a little bit of background for those of you who are not following Puerto Rico and PROMESA and all the stuff that I'm talking about carefully. And I will start out by saying, just kind of picking up on something Anna said, Puerto Rico is a territory of the United States. Probably everybody on this call knows, but maybe not everybody does. It is often referred to as a commonwealth, and that's as a result of a constitutional process in the 1950s. I kind of think of it as sub-sovereign, but you have to be really careful how you characterize Puerto Rico. In some respects, it's like a state. In some respects, it's not like a state. It's not like a state in the sense that Congress had the power to put an oversight board in place, which is what we'll be talking about. The status of Puerto Rico, exactly what its future is hotly debated. There's legislation right now that would try to resolve it. There are a number of different options. One option is to continue in some version of the current Commonwealth status, probably with enhanced rights for Puerto Rico and its lawmakers. Another option is for Puerto Rico to become a state. Another option is for Puerto Rico to become an independent sovereign, a country. And another option is sort of an in-between option, which is for Puerto Rico to become an associated nation in a sense. So a separate sovereign, but with strong ties to the United States. So the exact status of Puerto Rico is very much up for grabs, but the current status is it is a territory, it is a commonwealth. If you're critical of the arrangement, you would say it's a colony. That unfortunately is a fair characterization in many respects. So the three things that I'm going to talk about, one is I'll give some background to the legislation, which is called PROMESA. PROMESA means promise in Spanish. The legislation that created the oversight board and the restructuring process that I'll be talking about. So I'll talk about some of the events that led up to the legislation. Then I'll talk about the legislation itself and the oversight board and what the oversight board's powers are. I will then talk very briefly about the restructuring process. That'll be a 2 or 3 minute discussion just to give a quick timeline of the restructuring process of Puerto Rico's debt. And I should note here, as I may note again, when I talk about the restructuring process, it is the restructuring process for the debt of Puerto Rico itself, which is about $35 billion in debt overall. Puerto Rico plus its independent governmental corporations such as the electricity company, the water company, overall roughly $74 billion in debt. The Puerto Rico restructuring of Puerto Rico itself, about $36 billion of debt plus $50 billion of unfunded pension liability. So second, I'll talk about the restructuring process. And then kind of the core of what I want to talk about is two key innovations that came out of the process, which I think are relevant for sovereign debt. The first one is very relevant for sovereign debt, contingent value instrument, or CVI. The debt and pension management policies, which is the other innovation I'm going to talk about, also potentially relevant. And as we'll see, they're analogous in the management, the debt and pension management policies are in some respects analogous to a what the IMF does sometimes with its programs, the conditionalities that it builds in. So I'm just going to focus on two innovations. There were lots more innovations that were either used or were considered. Not all of those innovations were good innovations. And this is about to be an inside joke for Chapter 11, corporate reorganization, private corporate reorganization people. Not a very funny joke, but it will be a joke. And that is, as folks who follow Chapter 11 know, every time a proposed reorganization plan is amended, we increase the number. So you start with the first one. If you amend it, you call it the second amended reorganization plan, then the third amended reorganization plan. Our lawyers in Puerto Rico got tired of the number going up. So they vowed that the last reorganization plan would be the 8th. There would not be a 9th or 10th or 11th. And so the restructuring plan is the 6th modified 8th amended reorganization plan, or plan of adjustment. Not a good innovation in my view, but the two innovations I'll be talking about, I think, are a little more interesting. So we can go to the next slide. So the background to PROMESA, the prehistory is, at least as I'll describe, it starts in 1984 when Congress did something odd and unexplained in the legislative history of American bankruptcy law. The chapter in American bankruptcy law that allows the restructuring of cities and state entities, allows the restructuring of public entities, not states. States don't, there is no state bankruptcy, but Chapter 9 does cover cities and arms of the state. That's Chapter 9. For reasons that have never been explained, after decades of Puerto Rico having access to Chapter 9, meaning that Puerto Rico could authorize its governmental entities, its electricity company, its water company, could authorize them to file for bankruptcy. Decades after Puerto Rico had access to Chapter 9, just like every state has access to Chapter 9, Congress excluded Puerto Rico. Congress adopted a definition of what a state is for bankruptcy purposes. It said Puerto Rico and Washington, D.C., as it turns out, is a state for every purpose under any federal bankruptcy law in the U.S. except filing for Chapter 9. So Puerto Rico's public entities could not file for Chapter 9. And as we get close to the crisis that I'll be talking about, the entity that most people were worried about was the electricity company. It's called PREPA. And PREPA did not have access to Chapter 9. So Puerto Rico lawmakers, looking at Chapter 9, saying Congress took that away from us, thought, well, if we can't use Chapter 9, well, we'll create our own bankruptcy option for our public entities, for PREPA and other Puerto Rico public entities. So Puerto Rico enacted in 2014 something called the Recovery Act. What the Recovery Act is or was a restructuring framework that applied to governmental entities. It was very similar to Chapter 9, not to Puerto Rico itself, just to entities of Puerto Rico, such as PREPA. It had two main chapters. One of them looked like a sovereign debt collective action clause. It was essentially just a voting provision that allowed bonds to be restructured through a vote. The other chapter was a more traditional bankruptcy chapter. So it had a standstill attached to it. It had the ability to restructure obligations. I think it had a cram down. I'm forgetting now. I think it had a cram down provision. It had most of the key provisions of a full-blown insolvency system or bankruptcy system. Two law firms, and this will be a quiz that I'll quickly answer. Two law firms were involved in this. Cleary Gottlieb was involved, and Proskauer Rose was involved. The quiz will be guess which one drafted which part of the law. I bet Anna could answer that question. Cleary Gottlieb drafted the collective action clause part of the law. Proskauer Rose, Martin Bienenstock drafted the bankruptcy part of the law. So Puerto Rico passes its own bankruptcy law to try to deal with its financial distress. That gets immediately challenged in the federal courts. It is enjoined. It's essentially struck down by the trial court. The invalidation is upheld by the Court of Appeals. It goes up to the Supreme Court in the case on this slide, Puerto Rico versus Franklin, California Tax-Free Trust, which agrees with the lower courts that this is not valid. And the rationale is quite cheeky, but I think is a literal interpretation of the statute. And the rationale is Puerto Rico is not allowed to use Chapter 9, but it's also not allowed to create its own bankruptcy system that's a substitute for Chapter 9. So Puerto Rico has no bankruptcy option at this point. As a lot of folks on this call will know, I mean, there are ways you can restructure your debt, and it's possible if PROMESA had never happened, Puerto Rico would have tried a sovereign debt style restructuring of its bonds, but that proved in the end not to be necessary. So Puerto Rico is excluded from Chapter 9, passes its own law that gets struck down. 2015, the then governor says we cannot pay our debts. The debts are not payable. He throws up his hands. And that sets things in motion in Washington to adopt a response to Puerto Rico's financial distress. And we can go to the next one. Thank you. So June 30, 2016, Congress passes the PROMESA statute. What that statute does is it creates a 7-member oversight board. There's a complicated appointment process. The appointments process got challenged by bondholders, went all the way to the Supreme Court. Happily, from my perspective, we won in the Supreme Court 9-0. So I created a 7-member oversight board, gave the oversight board 2 main roles. The first is to certify 5 or more year fiscal plans. So each year, the board has to certify a 5-year fiscal plan for Puerto Rico. Puerto Rico's budgets have to be consistent with that fiscal plan, and so the board also certifies budgets. We're in the middle of that process right now. In the next 2 weeks, we will hopefully certify budgets for Puerto Rico and for a number of Puerto Rico entities. So there's a fiscal responsibility part. The board certifies fiscal plans and budgets. The second thing that the board does is it has the power to restructure Puerto Rico's debt. So PROMESA includes something that looks a lot like Chapter 9. It looks a lot like municipal bankruptcy. It's not called bankruptcy. The drafters of PROMESA were very careful not to use the word bankruptcy for a couple of reasons. One is because they wanted to enact it under the very expansive territory powers Congress has under the Constitution. The other is they didn't want this to look like bankruptcy for states because there were a lot of people who were willing to vote for PROMESA who would probably vote no if it looked like what PROMESA was bankruptcy for states. So it looks a lot like bankruptcy for an entity that has, in many respects, a lot in common with the state, but doesn't use the term bankruptcy. The restructuring part of, or parts of PROMESA, and it's 2 chapters or titles of PROMESA. There are 2 different restructuring tools in PROMESA. The first is called Title VI. What that is an elaborate collective action provision drafted by folks who are not experts in sovereign collective action provisions. Title VI is very, very cumbersomely drafted and very hard to figure out. Title III is a lot like Chapter 9, but the big distinction from Chapter 9 is that Title III applies not just to Puerto Rico governmental entities and municipalities, it applies to Puerto Rico itself. And that's why we could use it to restructure the Commonwealth of Puerto Rico's debt. We can move to the next one. So very quickly, the restructuring process with Puerto Rico. The board was put in place or was established by PROMESA June 30, 2016. We were actually put in place August 31, 2016. There was a standstill that went into effect the moment PROMESA was passed. That standstill was about to expire. It expired on May 1. We put PROMESA into Title III, into bankruptcy on May 3, two days after the standstill expired. We had 3 runs at a restructuring. The first run was in 2019. We had a proposed reorganization or plan of adjustment, as it's called. Proposed plan of adjustment, which I loved. It had a bunch of really cool provisions in it, but unfortunately it didn't have enough creditor support. So it died on the vine. In early 2020, we filed a second a separate reorganization plan. That one got sidelined by the pandemic, so that one never got to the voting process either. And then finally, in 2021, we filed a third proposed plan of adjustment. That was confirmed this January, and it became effective. It went into effect March 15th. So that is all this year. The key focus from the oversight board's perspective in this, there were a bunch of things that we were concerned about with the restructuring, but we put a lot of emphasis on trying to make sure the debt was going to be sustainable going forward, to minimize the amount of debt obligations Puerto Rico had going forward. And we determined in the negotiation process that the absolute maximum we were comfortable with Puerto Rico being required to pay for the next 30 years was 1.15 billion per year. So we called that the MADS cap, and I forget what the acronym stands for. But what we were solving for with the financial debt in particular was to limit the amount of debt going forward, and our line in the sand was $1.15 billion. Initially, it was $1 billion, but we let it slip up to $1.15 billion. So we can go to the next slide. So these are, I won't go into this in lots of detail. Folks who follow Puerto Rico might find this interesting. These are the major financial creditors in the Puerto Rico restructuring. Now, the pensions and the collective bargaining agreements with the unions were a very important part of this process as well. But here I'm focusing primarily on the financial creditors. These were the big groups. So there were general obligation bonds. Those are bonds that are backed by the full faith and credit of Puerto Rico. They're backed by Puerto Rico itself. Those bonds also are given special treatment in the Puerto Rico Constitution. The Puerto Rico Constitution says that all available revenues in any given year need to go first to the general obligation bonds. The general obligation bondholders took the position that this meant they had priority over everybody else. It was a plausible position. In my view, it was a quite debatable position, and this is something Anna and I have both written about in the literature. In my view, what bankruptcy protects is property rights, not payment flow rights, and in my view, there is a quite plausible argument that they didn't have priority. Our plan, as you will see, essentially ends up treating them as having priority. It gives them significantly more than anybody else. I had to swallow my academic commitments and put on my practical hat, and in the end, I was comfortable with this. But they definitely get the best treatment. So they had a roughly $18.7 billion in claims were general obligation bonds. They got $7.1 billion of cash. There was a huge amount of cash. Still is a significant amount of cash in Puerto Rico for two reasons. One is Puerto Rico hasn't been paying its debts, hadn't been paying its debts for 5 years, and so cash was building up. The other was all the federal money that was coming in because of the hurricane in Puerto Rico, because of the pandemic, and because of earthquakes in Puerto Rico as well. So what the general obligation bondholders got was $7.1 billion of cash, $7.4 billion of debt. They got most of the debt going forward, and a piece of the contingent value instrument. Second group is what I'm calling HTA clawbacks. HTA is a separate entity from the Commonwealth of Puerto Rico. It's the Highway Authority. Creditors of the bondholders of HTA had bonds that had a kind of interesting feature. And the interesting feature was the Commonwealth would transfer the funds to HTA for the payment of the bonds unless the Commonwealth was unable to pay the general obligation bonds, in which case it could stop transferring the funds. That's what the clawback refers to. It's a little bit of a misnomer, but the idea is the Commonwealth can stop turning over that money, which the Commonwealth did. And so the HTA clawbacks had a claim against the Commonwealth for their bonds, the payments for which were not being turned over by the Commonwealth. That was $4.1 billion roughly in claims. They got solely an interest in the contingent value instrument from the Commonwealth. They also are going to get payouts from HTA itself, but from the Commonwealth, they got a CVI. The other major set of clawbacks is PRIFA. PRIFA is a separate entity that is entitled to rum tax revenues that Puerto Rico gets. The PRIFA clawbacks had a $1.9 billion claim. They also only got a CVI, except they got two CVIs. They got a piece of the main CVI. They also got an interest in another CVI, a CVI that was based on the rum tax revenues. There were pension bonds that had been issued to cover up the fact that Puerto Rico wasn't funding its pensions and didn't have enough money to make the payouts it owed. They ended up getting a very low recovery because of a number of successful challenges to their claimed lien and their claim. They got $373 million in cash plus $71 million in what essentially is a loan portfolio. Finally, unsecured creditors, still not completely clear how much they're owed. The claims are still being sorted out. but they're going to get $575 million, which includes something called convenience claims. Small claims get paid in full. So big unsecured claims will get less than the $575 million. So general obligation bonds get paid a significant amount of what they're owed, somewhere in the 70 to 90 cents on the dollar, not counting interest that they never got. The other folks get clawbacks or cash. So we can move to the next slide. So the first innovation is a contingent value instrument. As I said, excuse me, we were solving for a debt cap, for keeping the debt at $1.5 billion. We had major disagreements with the creditors about the future of Puerto Rico. The creditors think that Puerto Rico is going to be a huge success and they actually could be paid in full. Joe Stiglitz thinks that Puerto Rico is going to go down the drain and that we're wildly overestimating what's going to happen in the future. The CVI was a way to bridge the gap. We could agree to disagree about what the future is, because if the future is good, the creditors get more under the contingent value instrument. If the future is bad, they don't get more. So it helped to solve for the maximum debt service ceiling that we had set. It helped to deal with our disagreements with creditors. We also needed something to pay the clawback creditors, and it turned out to be a currency we could use with the clawback creditors. The difficulty with CVIs, or the risk with contingent debt instruments or contingent value instruments, is they're really hard to structure. And they have sometimes misfired in the past. The classic place that people look for a contingent value instrument, or the classic yardstick, is to use gross domestic product as your yardstick. The problem is that's a manipulable number. There are other problems historically with contingent value instruments as well. One of them had been experienced by Ukraine. Now, I'm not sure what's going on now, but as of a few years ago, this may look different, a lot different now. Ukraine had used a CVI as part of its restructuring. The Ukraine CVI was not capped, and it ended up paying out a lot more than was anticipated. This was not just academic for us on the oversight board. As some of the people on this call will know, our executive director, our CEO, Natalie Jaresko, was the Minister of Finance in Ukraine when Ukraine agreed to the CVI and its restructuring. Natalie did not want to use a CVI because she was, at least for much of the process, because she was really leery of the way they could go wrong. In the end, it was both necessary and I think we controlled for the most obvious unintended consequences. That's sort of a contradiction of terms, but we controlled for a lot of things. What we used was we keyed it to Puerto Rico's sales tax revenues, which had a number of attractive features. One attractive feature is it's a small portion of Puerto Rico's overall revenues. So it's only a little piece. It was about 7.6% maximum of Puerto Rico's revenues that would be at stake with the sales tax CVI. It's also much harder to manipulate than GDP is. The sales tax, it's conceivable you could manipulate the numbers, but they're much less manipulable than a lot of measures for a contingent value instrument. We can move to the next one. And the next slide just shows, I think it's a cool slide. It's more complicated than you need to see at the moment, but I'll make these slides available if anybody wants to look at them. This shows how the CVI works and who gets what. So the gray part at the bottom is what goes to the general obligation bond. So they get a big chunk of the early payout on the CVI. The darker blue bars are what goes to the clawbacks. So they get about 50% of the early payout. The payout ends for the GOs, and then we could give 100% of the CVI and still stay within our debt limit. We could give 100% to the clawbacks. These, the final bars, fiscal year 44 to 52, we extended the duration of the CVI more than we would have liked to have, but that made it possible to give a real recovery to the clawbacks. That was something that they would agree to in the end. The light blue bars at the top is a piece that we preserved for the Commonwealth. So the Commonwealth always gets a piece even of the revenues that are going to the CVI. And the revenues that are going to the CVI are not all of the sales tax. At this point, it's about half of the sales tax that's going to the CVI. And the Commonwealth gets 10% of that half of the sales tax that's going to the CVI as well. Next slide. This shows how the debt service changed as a result of the plan. On the left is what the debt service looked like before PROMESA. So what Puerto Rico would have faced absent PROMESA, and you can see that there's some years where the debt service is really high. It at one point goes up to $3.9 billion. On the right is what the debt service is under the plan of adjustment. It is capped at that 1.15. If you look at the gray and green bars, there are a couple places where they go over the 1.15. Those are those blips upward. That's a little bit misleading because the additional part is being used to pay a small subgroup of the bonds, and it's coming out of a reserve fund. So it's not actually coming out of revenues, of new revenues of Puerto Rico. So the max is 1.15, the max in reality. We can go to the next slide. I'm almost finished. I'm mindful that I'm past my 20 minutes, past my 30 minutes, but I'm just about finished. This is the next. Oh, well, I have 3 slides, including this one. So the other big innovation is that we put some debt and pension protections into the plan of adjustment that the court confirmed. And the concern, not surprisingly, was that once this plan of adjustment is in place and once the oversight board is gone, there's a risk Puerto Rico would slip back into the same old bad habits that got it into financial distress in the first place. So we built some protections into the plan to create a runway, essentially to create a 10-year runway where it is highly unlikely there will be problems because of the debt protections and the pension protections. So we can go to the next slide, which is the next to the last slide. What we did with respect to debt is we put a cap into the plan of adjustment that the court confirmed, which is much lower than Puerto Rico's constitutional cap on debt. The constitutional cap on debt is 15% of Puerto Rico's revenues. That's the maximum debt service that's permitted in any given year. We put a cap of 7.94. This is not completely apples to apples. It's based on not exactly the same revenues, but it is still well below 15% for the next 10 years to limit near-term borrowing. The plan for the next 10 years also only allows long-term borrowing for capital improvements, not for things like payment of debt, which was what a lot of the earlier debt was used for. And it has some other protections in it as well that essentially limit the amount of debt that is permitted and the kind of debt that can be issued. We can move to the last slide. We did the same thing with pensions. The plan of adjustment completes a shift of Puerto Rico's pensions from defined benefit, where it guarantees payouts when someone retires, to defined contributions, where it guarantees only that contributions will be made year by year. Puerto Rico had already started the transition. The plan of adjustment completes the transition. There were no cuts to accrued pensions, to the accrued defined benefit promises that had been made. They were not cut at all. So there's even less of a cut than there was in Detroit. In Detroit, there were small cuts to the pensions. There were freezes on COLAs, so there was an effect on the pensions, but there was no monetary cut to pensions. To prevent against the possibility that Puerto Rico will have financial trouble in the future and won't be able to pay all of these accrued obligations, the old defined benefit liabilities, we created a trust under the plan that commits a minimum of $175 million a year, a maximum of 50% of Puerto Rico's surpluses for the next 10 years to a trust. That is expected to set aside at least $10 billion to protect the pension payout in the future. Why did we do that? We did that because our fiscal plan projections suggest that when the federal money runs out, Puerto Rico may well have some financial trouble again. And so while there is money around, the plan of adjustment requires that it be set aside for pensions. The one other thing that I'll mention is the next to the last bar, which is a 10-year prohibition on the legislature creating new defined benefit plans. Our concern is that what the legislature is going to do is going to start giving away promised money again, and there are hints that that's exactly what it would do. We put a provision into the plan of adjustment that makes that invalidates any attempt for the next 10 years to put in place a new likely to be unaffordable addition to the pension plan. That's defined benefit. That's making promises for the future. Puerto Rico has lots of money and they want to set more money aside in their defined contribution plan. They can do that. What they can't do is create a new defined benefit plan. This is something we stuck into the plan of adjustment at the very last minute. We were in the voting process at that point, and we were worrying about, well, what happens if the legislature just starts passing pension benefits that it can't afford again? One of our advisors said, well, in Detroit, we put a provision into the plan of adjustment. And we said, gosh, that sounds like a great idea. Let's do that too. And so we put this 10-year ban into the plan of adjustment. So putting all this together, two very big innovations, the CVI and using the plan of adjustment to limit in the near term for a 10-year period potential reversion to the problems of the past, both with respect to debt and with respect to pensions. And I'll stop there at 40 minutes, I think.
David, you're the star attraction. So if anybody runs over, you get to run over. Thank you so much. There's so much food for thought here. Let's see, why don't I try to figure out how to stop sharing? Boom. And then, Ted, it's your show, and then we'll see how much time I might have left.
Great. I really appreciate David running over because he gave me more time, more things to say and less time to say it in. I've just put up a couple of slides. I should, let's see, are they? Yep, okay. I want to start off by just saying, because I think the last thing I wrote that addressed David was beating him up, is that this is just a tremendous accomplishment, and I really think it's there's no way that a restructuring like this leaves everybody happy, and that you don't end up taking lots of slings and arrows in the process. And I think the fact that this appears to be steering itself home is just an extraordinary success. And I think and what I want to take a second to do is think about some of the lessons about how you got there, and to focus not so much on just how it happened, but to focus on the fact that a restructuring like Puerto Rico, a restructuring like Detroit, raises, and I used the word sub-sovereign, and I just learned that I shouldn't have used the word sub-sovereign with regard to Puerto Rico. These sorts of restructurings raise profound questions about the interaction between politics and, I was going to say politics and markets, but politics and debt markets. And I want to sort of lay out some stuff. Then this is, in what I'm about to say, I owe a tremendous debt to Melissa Jacoby, who I think who really thought this stuff through in this regard in the first instance. So I am sorry she couldn't be here to do this, but I'm stealing from her liberally, and then I will put my own spin on it. The point is that once, if I come from the private bankruptcy world, where we care about the sustainability of the debt in the sense, is the plan feasible, is value being allocated, but it's all about money. But once you move from a municipality to a city, to a territory, to a nation, as you move up that or down, I guess the way I've written it, but up the level of sovereignty, the interaction between debt service and governmental stability and legitimacy of the government and the legitimacy of the debt begin to interact in much more complicated ways. And Puerto Rico puts us in a very sort of interesting middle ground, somewhere between sub-sovereign and sovereign, and forces us to think about this. And the way I tend to think about cases like this is to think of them weirdly, not so much as being like bankruptcy cases, but as being, at least to the extent that we're talking about these happening in the US in a judicial proceeding, more like structural reform, constitutional and constitutive litigation that we would see in a school desegregation case or a prison reform case, where a judge or a judicial proceeding is handed in some complicated way the administration of a public institution and needs to both get it back on its feet, exercise some degree of power, and preserve the legitimacy of the institution all at the same time, which is a tremendous tightrope walk, right? The point is that in these cases, the legal norm, cruel and unusual punishment or equal protection, imposes a norm on the institution, but the type of reform that happens has broader implications. And that's true also where what you're trying to do is restructure debt. How does one balance the obligations to creditors against the need to provide essential services, provide for citizens, and also maintain the legitimacy of the political institutions, and to a certain extent to the governing regime that's doing the negotiations? And this is just something that I don't know, it seems kind of impossible, and emphasizes the fact that the extraordinary nature of the accomplishment, right? And the question then becomes, how do you coordinate the process? And this is where both Detroit and Puerto Rico end up providing a bunch of lessons that are important. And this is where I'm borrowing from Melissa, her idea of the blueprint, which is these cases seem to have a common set of institutions. I guess on some level pioneered all the way back when New York restructured itself back in the 70s, which is, although New York didn't have a judge, here a judge, a mediator, and then a mediating political institution of some sort, either a control board, an emergency management team, or whatever, or what have you, that can take the money problem and then manage the interaction between the money demands and the political institutions. Now, the trick here with these institutions is you've got this gap between the norm, the legal norm, pay the debt, and the legitimacy of the institutions and the power of the institutions and the authorization of the institutions to do the things that need to be done in order to get that done. And if this process works well, it can create what I'll call a legitimacy feedback loop, right? Where once there's a deal, the various entities both beat each other up, but at the end of the day, walk arm in arm. Or actually, in the case of the oversight board and the executive director, the one group that ends up getting to take the heat for everything is the oversight board and the executive director, preserving the legitimacy of the political institutions and getting to yes on the debt. Again, thank you for your service, David. So that's sort of the framework or the way I think about this. And with that, and this is, I'll just make two quick points. I want to take the two innovations that David talked about in his talk and evaluate these innovations on the legitimacy axis and see how they play out. And I will say, I've been thinking about this for all of a day and a half. And so this is just very, very tentative, but I think really interesting. And so the way with the two innovations are the contingent or the variable debt instrument, and what David described a bunch of things, but I'm going to generally put them in the category of loan covenants, right? Right, and so these are the two things, and I want to talk about them separately. I'm kind of really, really intrigued by the effects of the CVI, right, as a device in this sort of negotiation. It does something really interesting, which is it creates a risk-sharing arrangement between the incumbent creditors and the state. And actually, I think one of the things that was really most interesting about the CVI is the interest aligning effect of giving Puerto Rico some residual skin in the game on generating sales tax revenue, right? I might have maybe made the slice a little bit larger, but the fact that there is a slice in there deals with, in a very interesting way, both the politics of this, we're getting some of it back, and the incentives, which is to say, make sure that they stay obvious. I should say it again. The other nice thing about it is, and Puerto Rico was just such a great, horrible example of the degrees of unknown unknowns that can affect the economy, even during the course of trying to negotiate a deal, from Katrina to, to COVID, to everything, right? You can deal with these unknown unknowns because the terms of the note are very depends on what happened. But you still, and this is where you need to be careful, need to allocate the risk of the known unknowns in ways that make sense. And that's something that I'd like, David, you didn't go into that much detail on this, but I'm sure that that was one of the issue of the GDP bonds versus the sales tax bonds. I think it was a really innovative and interesting way of making sure that the known unknowns were allocated to the right side of the equation while preserving the unknown unknowns as a possible, for the variability in the interest. Now, one question you might ask is, if these things are so cool, like, why don't you see them more often in T1 built into the bonds right up front? And it's really, this sort of highlights a really interesting aspect of bond markets, which is everything in T1 is oriented towards making sure that nobody thinks that anything like this can ever happen in a million billion years, right? The market won't tolerate it. They want a credible promise. And also, maybe you don't want creditors to be equity owners of a state or a political institution. But I think there's some thinking to go into, like, why is it that this happens here, but couldn't and wouldn't happen in T1? Okay, so that's, I think, a overall sunny view of the convertible or the variable debt instrument. Covenants, I think, are a more complicated proposition in terms of legitimacy. They're sort of constitutional debt instruments, right? You're basically putting in place dead hand governance and saying the future administration is going to pay for the sins of the prior administration. Now, this is, this is sort of the opposite thing, which is we're trying to make sure that even in T2, we're making a credible promise to do something in the future. And so how do we make it credible? And the problem is it has the same problem as bond markets in T1, which is the need to overpromise. Right? There's often the need to promise the world, to bind your hands, to commit yourself in the future, which, and this is something that is problematic, which the politicians doing the negotiations are negotiating over a time horizon that exceeds their political accountability. And this is just a problem with public debt. Which is you're always dealing with an intertemporal externality between the people who are negotiating the deal and the people who are going to actually have to deal with the choices that are involved in paying it after the fact. And I think, let me just see if I want to wrap this up and give Anna a chance to talk. Yeah, so the point is that the question is, what can you do, right? Or let me put it differently. Is there a difference between the risks associated with the dead hand governance of the covenants in T2 from the dead hand governance in T1? And I actually am going to suggest very tentatively that I'm less worried about the kinds of covenants that you put in place here than I am about the general attempt in T1 in an ordinary bond issuance to cut off and tie the hands of the future. The problem is in T1, everything is about promising credibility of people who aren't involved yet. And the other thing is it's an arm's length negotiation where you have to deal, where the debtor doesn't have any leverage and has to entice the lender to lend. The one thing that really changes in the context of these sovereign debt restructuring negotiations is what I'll call mutually assured destruction. The bondholder's in. And so there's actually a little bit more leverage in the hands of the debtor to negotiate over those covenants and make sure that they don't overly tax the legitimacy going forward. Also, and the other thing that I think is useful to think about here is legitimacy is on the table at the time of the restructuring, so it's factored in. So I think I'll just close off with those reflections and say, kind of, wow, a lot to think about there, and some really interesting and promising tools developed that I hope are helpful in the future. Thanks. I'll stop the share.
So, Ted, thank you. And this is a reminder for everybody. Please, if you have questions, put them in the chat. And the more questions you put, or any questions you put in the chat, will spare you the internal conversation loop, and I think it'll be a public service. So, because the three of us have been talking about this stuff on and off since before times. I mean, I learned about priorities from David a very long time ago. And thank you, Arturo. I have just a couple of thoughts that I think emerge from really the combination of David's incredibly instructive and accessible presentation. Is probably one of the more accessible but not dumbed down presentations about Puerto Rico that I've heard, and Ted's emphasis on the politics of it all, the structural challenge, and political legitimacy. So the reason that I keep wanting to hear more and more and more about Puerto Rico, and I think that'll be there for a good long time, is that this is the one time, I would argue, that we have seen anything like the kind of sovereign bankruptcy, sovereign statutory bankruptcy experiment that we've been talking about for decades, and by some measures longer, right? So the thing that I keep wondering about is what lessons does it hold for the bankruptcy of states, not just states in the United States, but nation states and otherwise organized states. And Ted's presentation, Ted's reaction to David's account, I think really makes me ask the fundamental question. And the title of this panel, which is, to what extent are private law instruments suited to deal with the kinds of structural, political, fundamentally constitutional problems that we see in Puerto Rico? And how far can you get with instrument design, contract design, right? So can you solve a political problem with a contract as perfectly designed as you can imagine? And the kinds of questions that emerge from that might be, look, how important is the presence of the federal government in the picture, right? I mean, David, it certainly seemed important in the time horizons and kind of flow considerations in the plan, but I suspect it, and they were also front and center in the legitimacy conversation and the political kind of predicate for this entire enterprise. And I think your introduction certainly pointed to it. And, certainly Melissa Jacoby has written a lot about this. Odette Leno, who's on this, by the way, congratulations, Odette, on this screen, has written about legitimacy in a very thoughtful way. How there's the legitimacy conversation before, and then there's the legitimacy conversation during, right, the crisis management itself, and then there's the legitimacy conversation long term. And I was absolutely fascinated by what seemed like an aversion to long-term commitments in the output, right? So, some might say what you want is for Puerto Rico to issue perpetuities, but it's constrained in issuing long-term debt, never mind, perpetuity. So that was sort of interesting. The other question that I have, and certainly Ted referred to this, climate, my goodness. I mean, I remember having this conversation about Puerto Rico and the structural challenges at the around the first post-PREPA hurricane, right? And then the second post-PREPA hurricane came. And so this question about us treating these events, particularly public bankruptcies, as one-off or susceptible to decisive solutions, you know, seems a little bit iffy or, you know, risky or perhaps divorced from our climate reality, at least. And then the very last point, I was absolutely, I mean, this is one of like lifetime light bulbs went on in my mind when you talked about CVIs as currency, my friend. I think that is the best and rightest way to talk about this, right? And of course, the debate about contingent debt is sort of like, you know, economist honey. I don't know. It's like, I don't, you know, what's
law professor honey.
That too, but like I mean, good, like the number of Nobel Prize economists who are, you know, all about state contingent anything, state contingent anything that moves, right? I mean, this conversation has been so long running in the academy, and Ted's sort of time one, time two setup certainly goes to this, right? I'm fascinated by the fact that, you know, somehow inflation index debt survives and GDP index debt doesn't. But the way that you frame this strikes me as exactly right, right? So the CVIs we have had up until now are more like, you know, currency that's pegged to stuff, right? So be it gold, be it, you know, some basket of something, be it, I don't know, intergalactic vibes, it doesn't matter, but it's not fiat currency, right? But I do wonder, and you know, I know there have been some proposals to that effect, if you made CVIs more like fiat currency, where really you're looking at, you know, full faith and credit, or, you know, the sort of, is this sovereign entity good for the money, right? Whether that could shift our thinking about this. So those are just some disjointed thoughts, but we've got questions, folks, and what I would like to do is kind of put them in with my own musings and then ask David and Ted to respond. So there's a question from Greg Makoff about how we think about COFINA, right? This is the tax, you know, the other tax-supported vehicle, and how it fared in the plan. Then let's see. There's snide comments from John Potto. We love you, John Potto. And then that's about David's timing. Arturo Porzakonski, reflections on how liabilities to the retirees of Puerto Rico's government and government-owned enterprises were treated vis-a-vis bondholders in comparison to Detroit. We have a scary number of very informed questions, my friends. Ed Bartholomew, seems like Puerto Rico pension benefits are treated in effect as super senior. Should state muni holders and rating agencies assume the same rule would apply in U.S. states? That strikes me as two questions in one. Why don't we pause there? And David, you have the floor. You can pick and choose, and then Ted.
Okay, there's so much great stuff here. And Ted, thank you for not making good on your vow to talk fast. You talked at a normal pace and were understandable, which I really appreciate.
And by the way, as an uninformed observer, I yield the floor entirely to David for the remaining time.
Well, you can jump in too, Ted. I'll just make some comments on each set of responses. I'll try to keep them short. So with Ted's, I'd love the political legitimacy point, that it becomes more of an issue as you go up the sovereignty ladder, in a sense. I think that's right. And a couple of things relevant to Puerto Rico, none of which undermine that, I don't think. One is you don't get into this kind of a mess unless the democratic process is broken down. So So there's already a legitimacy issue, which I think weighs in favor of the intervention. You know, that an intervention we would not tolerate in other contexts is defensible in this context. One of the things that struck me, well, actually, I'll save this for when I talk about sovereign bankruptcy, which Anna raised. The tension between financial obligations and political kinds of concerns. One of the places this has really come out, I think, in municipal bankruptcy is in the emergence of the idea of service delivery insolvency. So it's not just a financial insolvency that courts are looking at. They've kind of rewritten the rule to focus on service delivery insolvency, which I think is bringing a political dimension into the financial discussion. But the political legitimacy, the legitimacy feedback, I think is really important. And I like the general comment. And it's tricky with Puerto Rico because Puerto Rico is pretty high up on that list. Second point about why don't we see CVIs in initial debt instruments issuances. I mean, one thing I'll say there is the creditors did not like the CVIs. I mean, it was very interesting that they said that we were really underestimating Puerto Rico's revenues, that Puerto Rico is going to have all these extra revenues, but they did not value a CVI highly. It was only useful to close the deal, you know, once everything else had been negotiated. And I think the reason for this is because the market has difficulty valuing a CVI. And so they're afraid that that they won't get what they think the value of the CVI if they want to trade out of it. On the dead hand control point, it's a really good point, and I think it's a really big issue. We did talk about it. I mean, the 10 years was not an accidental number. I mean, that was about as far out as we thought we could justify. I mean, the oversight board will still be there for a few of those years. But that is a real issue, and I think it's one that courts will have to wrestle with. How much dead hand control will we allow? And I think the number of years will be key, and the extent of the constraint will be key as well. The one limitation on our pension constraint is we didn't say, Puerto Rico government, you can't give people bigger pensions. We just said, if you do that, you have to do it as defined contribution. You cannot do it as defined benefit promises. On Anna's point, implications for sovereign bankruptcy and the role of the federal government. I do think the federal government is really a key player here, and it did neutralize, I think, some of the sovereignty concerns you would have in the international space. And so I come out of this, I was one of the advocates of sovereign bankruptcy in the early 2000s. I'm often in the minority on these kinds of issues. I think it's complicated. I mean, is there an entity in the sovereign space that can play this kind of role? I was worried about a court overseeing a commonwealth or a court overseeing a state. It actually has worked out okay in Puerto Rico because the judge has been very careful about democratic legitimacy and limiting the intrusion on it. The third part of it is just Puerto Rico law. Puerto Rico law limits debt to 30 years. But there also is the kind of binding the future concern about debt instruments. I mean, our debt instruments go out a long ways, which makes me a little queasy even with what we've done. More than 30 years would be a problem. The one-off thing, is this really a one-off problem or is it going to recur? I think there's an argument for going to collective action clauses. If you think that's where things are headed. I mean, we really looked at this as once and done, only one chance to put Puerto Rico in bankruptcy. There's not going to be another opportunity. Greg's question about COFINA, I deliberately didn't talk about COFINA just to keep the complexity of the conversation down, but those are the original sales tax bonds, which were separated from Puerto Rico, purported to be a completely separate entity. That was litigated, as Greg knows. A couple of things on that. Interestingly, they were 40-year bonds, which would not be allowed for Puerto Rico debt, but Puerto Rico took the position that this is not Puerto Rico debt, and so it's not subject to the constitutional debt limit. Whether COFINA, and it's the same kind of strategy Chicago has used and a few other sovereign public entities have used, which is to carve off a revenue stream and to use that to get around debt limits, arguably. Whether it's legitimate or not is debatable, and that was not finally resolved. There was a deal that was reached between the Commonwealth creditors and COFINA, which was roughly a 50-50 split. COFINA got a little bit more. So if you read that as the strength of the legal arguments, slight advantage to COFINA that was a legitimate structure. The questions about retirees, I think at this stage in the game, pension obligations are a priority. They were only adjusted a little bit in Detroit. They weren't adjusted at all in Stockton. Puerto Rico had $50 billion of unfunded pensions, and none of those pensions obligations were cut. That was the political reality. I think the political reality is that pension obligations have a kind of priority status. They can be adjusted, but they can't be adjusted dramatically. And I do think rating agencies need to take account of that. I mean, after Detroit, after Puerto Rico, it is very clear that they are not treated the same as financial creditors. And I'll stop there, and Ted can jump in if you want to.
So, John Potto, how strongly do you feel about your question about hating on control boards?
John's always good for to make me know how much I loved.
And then also he asked a question about service insolvency, but I thought that actually it was very similar to kind of the answers close to the last question you had on the on pensions, which is that there's a realism to the political realism there.
Yeah, I mean.
All right, dude, like you need to give me a scale, 5 out. All right, never mind. You know what, Ted Banger, do you have anything to say?
Oh, me? No, so we've got 3 minutes, and the one thing I had to say is sort of an off the side thing about the treatment of secured creditors, which will take more than 3 minutes. So I think probably I should just let Anna, why don't I just give it to you to wrap it up, and that way we finish on time.
Let's see. Thomas Laurier is asking, all right, that question has been answered, Thomas. I'll tell you offline, or you can watch the video. It's about the lessons about purely statutory approach in the sovereign context. Folks, first of all, David, thank you very much. And thank you, Ted, and thank you, III, and thank you, all of you who joined us, and our co-hosts and everybody who watches us on TV after this. I think we're going to be talking about Puerto Rico for a very, very long time, maybe longer than 30 years, David. So pace yourself.
Yeah, I hope we're all around in 30 years. It's quite possible.
Well, 40. I was ending on a cheerful note, people. And I think that, to me, the really important thing here is that we put this question of financial viability, structural viability, and political viability kind of in the same mix that is really the defining mix of sovereign debt problems to my mind. And since I'm closing us up, that's how I'm gonna rule, hashtag sovereignty. And I don't think that we can afford to drop any one of these. So this is hard. This is not going away. There will be DebtCon 6 and 7 and 8.5. And that was an Italian joke that some Italians made in Italy. Hello, why? And
it's a Fellini joke.
Exactly.
I didn't get it until you said that, Ted.
Interdisciplinary people. So look, this is incredibly hard. The one thing that we haven't talked about really sort of head on is something that David opened with, which is the colonial question, right? Which is sort of the a harsher framing of these. So what is federal government doing here? And
Odette put that into the chat as well.
Terrific.
Yeah.
So to be continued. And thank you again.
Start as people come in to do the non-substantive part of introducing the panel, laying out the ground rules, and getting us off to a start. So the DebtCon format, I am told, it involves always two panels, one a paper panel and one a policy panel. The last panel was our policy panel, and this panel is our papers panel. And this, I think, demonstrates something that is I don't know if it's a sovereign debt thing or just an academic papers thing, which is if you take three really good papers and two interesting topics, and you don't even necessarily see an interrelationship with them, but put everybody in the same room, common themes will emerge, and the conversation will develop its own coherence. And I think picking up the themes of Puerto Rico from the last panel, there are a bunch of natural overlaps between the papers that we're going to hear about today. Our three speakers are Jay Westbrook from Texas. Everybody knows him. He's going to be talking about the Russia-Ukraine bond dispute and the interaction between politics and private debt. Winnie I never connect Kiryabwir. That close enough?
Yes, you got it.
Is going to be talking about COVID and its effect on bank stability in Uganda. And then Adam is going to be talking about municipal bankruptcy in India. And we'll see again the interplay between politics, unknown and known unknowns, and the relative strength of institutions that are not just private bankruptcy, private debt resolution institutions. The way we're going to proceed is we've allocated a half an hour to each paper, and we'll go in order, dealing with the papers in one at a time. I've asked each speaker to aim at speaking for about 15 minutes, and I have no control over whether they actually do that. I will then ask a first question, but then the hope is in this panel that will then we'll move to a more general discussion. And differently, I think we'll try it this way. Rather than putting your questions in the chat, just put your hands up and I'll manage the queue. And if the queue is short, I'll riff. With no further ado, I'm going to turn the floor over to Jay Westbrook for Russia and Ukraine and gunboats. There you go.
Thank you, Ted, very much. The morning program was, or the earlier program was terrific. I hope we can try to match that. My topic today is bailiffs for gunboats. It's the case in the English Supreme Court between the Ukraine and Russia. It's a fascinating and unusual case. And I look forward to talking about the various aspects of that case. I am not super adept with all these different screens, so forgive me. if it is a rough go. The case is called Bailiffs for Gunboats. I wrote it for a fest shift for our dear friend of so many people on this Zoom, I'm sure, Christoph Paulus. There's a summary and credit slips. There's the link, and the Court of Appeals decision that I'm going to talk about is right below. Royal Courts of Justice is where we're going to be. Let me start off by talking about Ukraine versus Russia in the context of it being one of the most remarkable cases of, whoops, come on now, there we go. One of the most remarkable cases of recent years involving the intersection between public and private law. Ukraine versus Russia is a multi-billion-dollar case, argued and re-argued in the English Supreme Court, and most recently in November of last year, and yet still without a final judgment 4 years after Russia lost in the English Court of Appeals. It represents a remarkable encounter between public and private international law. If you teach this stuff, you know, you always start off the international law course saying, well, there's this distinction, there's public international law and there's private international law. And then you immediately kind of look at the floor and say, but on the other hand, the two of them are merging together ever more relentlessly over the last 50 years. This case is one of the ultimate examples of that blurring together of public and private international law. It's remarkable that it's attracted so little commentary over the 6 years since the case was commenced in London. It's especially remarkable because of the decision of the Court of Appeals. The Court of Appeals issued a decision with 5 judges on the panel. And on top of that, the decision was one that was allocated among the 5 judges who took different aspects of the case, different issues in the case to discuss, although all of them joined together in one judgment, all very different from the usual way that the English Court of Appeals operates. Ultimately, the case presents really interesting issues of both current and future enforcement of sovereign to sovereign loans. So that's our category today, is sovereign to sovereign loans. The central question that I want to discuss is, should political and diplomatic advice be sought by courts when asked to enforce an apparently commercial obligation against a sovereign debtor, when the creditor seeking enforcement is also a sovereign and may have substantial political objectives in that enforcement? So that's the overall question. The legal context, it starts with, of course, the traditional shield of sovereign immunity. Can't sue a sovereign state in the domestic courts. And the fact that in recent years, increasingly that rule has been abandoned in the case of sovereigns who have issued public debt in the form of bonds or bank debt or whatever. Sovereign immunity has not been enforced. And furthermore, a corollary of that, which is seeking the advice of the political departments of the enforcing state, has also been put to one side. I want to argue here that where the plaintiff lender is also a sovereign state, that we should return to the idea of incorporating advice from the diplomats before deciding whether to grant normal standing in the case. In this short discussion, I'm just going to give you a rough summary of the facts, basically from the Court of Appeals decisions. There are many things that people would argue about as to what the facts of the case might be. But these things are fairly clear. Ukraine issued a note for the repayment of a multi-billion-dollar loan from Russia. Ukraine takes the position that Russia insisted on making that loan in lieu of Ukraine getting a similar loan from the EU, the European Union, because they thought that was not a good idea politically. So the documentation, however, for this sovereign to sovereign loan was quite unusual. It was in normal commercial form. It was specifically written to be suitable for trading and was promptly listed on the Irish Exchange. The note was governed by English law and provided that any disputes would be resolved and enforcement would be sought in the English courts. Ukraine stopped making payment on the note around February of 2014, about the time that the hostilities arose in the eastern Ukraine, supported by Russia. In 2017, Russia filed suit, that is to say, the Law Debenture Society, nominally, on behalf of Russia, filed suit in the High Court in London. Ukraine asserted several defenses, one of which was duress, and that's the one I really want to focus on today. Again, forgive my slowness in these things. There we go. So at the High Court in London, the court dismissed Ukraine's defenses against enforcement, including duress. It accepted that a duress defense might be available for an ordinary party, but said it would not be available to Ukraine because assertions of war and violence and things of that sort by a sovereign state against another sovereign state were simply not justiciable in an ordinary commercial court. I don't do this stuff, in effect, is what the judge in London said. That decision was then appealed to the Court of Appeals, not very far to go, of course. And that brought us to the decision of the English Court of Appeals, that 5-judge decision that I mentioned a moment ago. There are two key elements to that decision. One, Ukraine was entitled to assert a defense of duress against enforcement of the note, just like any other debt on a commercial note. Two, in the alternative, if the duress defense was not available, or was not justiciable as a defense to an enforcement suit by a sovereign lender, then the entire case should be held non-justiciable by virtue of that fact. As you will see from the discussion that follows, I have to say, I think both of those points were really insightful decisions in light of this very unusual case. So one way to, I should leave that up. One way to summarize what the Court of Appeals decision said was that the Court of Appeals said you can't mix the rules of two different games. You can't say you want to play football, but you want to use the rules of golf, or vice versa. You have to do one or the other, and you can't tackle your opponent on the golf course as if you were playing football. So in much the same way here, you either have to decide it's a public law case, and the English Court of Appeals invited, very interesting, invited Russia to go to the World Court or to go to international arbitration to resolve the case. And it's quite interesting, of course, that Russia did not choose to do either one of those things. Why would Russia ask for this note in commercial form, like a loan to a private party? Why would it subject itself to the control and ruling of an English court under English law? What a strange course of action. I start in thinking about this case with Professor Paulus's explanation to us, that's a couple of different articles, of the fact that every debt contract creates a power relationship, and that it's really important, whatever else you understand about contract law and debt law, that you understand there is a power relationship in every such arrangement. Enforcement of a civil debt in a civil court, third-party civil court, has maybe an attractive alternative for a sovereign who wants to enforce it to get repayment, perhaps, but also for other political purposes. In the case of Ukraine, in light of the subsequent developments, it's reasonable to infer that Russia may have envisioned being able to use private enforcement in London and in other financial centers, including the United States, for the purpose of using the judgment, a resulting judgment, to seize assets or to grab commercial debts. For example, maybe debts owed to the debtor sovereign by various commercial corporations in the enforcing state, or elsewhere. A sovereign might want to employ bailiffs instead of gunboats, and thus my title. There are lots of unattractive things about employing gunboats. We've seen that in the last several months in the Ukraine. Another way of applying pressure without all of those costs is to use the force of enforcement of a commercial judgment. Kind of suits that we've had in the United States and North America by vulture funds against Argentina have helped to demonstrate the very substantial force that is involved, even in a sovereign situation, in enforcing debts. Professor Paulus also has written about the fact that that frequently with a sovereign debt, there are political objectives that are beyond mere repayment. He points to the fact that even in private debt collection, we have, for example, loan-to-own arrangements where a lender provides a credit or provides a loan to a debtor, actually anticipating default, maybe even hoping for default, because of the possibility of using the creditor remedies to acquire the debtor. So in a somewhat similar way, sovereigns can use suits, ostensibly commercial lawsuits, to seek additional pressure for special political or territorial concessions, taking advantage of the notion that sovereign immunity does not apply in the case of ordinary commercial transactions. This is, of course, not a development likely to have been anticipated by those who thought of abolishing sovereign immunity in ordinary commercial cases, or in saying, let's judicialize that sort of a case and get the political people, the Justice Department in our country, or the Department of State, or a foreign ministry, let's get them out of these cases. They're simply commercial. And really, I think this case raises the question of whether any suit by a sovereign against a sovereign can ever be considered merely commercial. These are not cases like suits by bondholders or banks who almost always just want to get paid, for God's sakes. No, these are suits that almost always will have other political ramifications as well. And forgive my ineptitude in wrestling with these various screen possibilities. There we are. And therefore, in the Ukrainian case, the Court of Appeals reached the conclusion of non-justiciability on its own. But it may well be in many of these cases where there's a suit by a sovereign against a sovereign, where it will be ambiguous. It won't be entirely clear whether there's some underlying political agenda or whether the sovereign creditor, the sovereign lender, just wants to get paid. One doubts that in too many of the cases that will be true. Almost always one thinks, or at least I speculate, that there will be a political objective as well. And that's something about which the political departments of the enforcing state will both know a lot more and be able to cast some light on what the interests of the enforcing state might be in enforcing this otherwise ostensibly commercial obligation. It's quite possible, for example, that the Foreign Office will have information about those underlying objectives or underlying impact on the interests of the enforcing state that will not be available to the judge. I would recommend to any of you who are interested in these issues that you go look at the arguments before the English Supreme Court. One most recent one in November of last year. Fascinating stuff, readily available. I guess I can post the link for everyone who's who's interested. What's striking, I can't begin to comment, I'm not competent to comment, on all the wonderful intricacies of British commercial law that were discussed by the very able judges and able lawyers in that argument in November of last year. But what is really striking is that it was all about the intricacies of commercial law. What it wasn't about was all of the underlying realities at a time that was just over 3 months before the tanks started to roll and the missiles started to be fired by both sides in the Ukraine. One has to feel that the judges would have been well informed, would have been well served by being informed by the United Kingdom Foreign Office, and that the Court of Appeals alternative decision of non-justiciability was one that perhaps had a lot to recommend it. Thank you, everyone. That's the case literally in a nutshell, and I'd be more than delighted to hear the comments of my panelists and all of you who are listening. Thank you.
So I'll jump in with the first question, and then Winnie, Adam, if you want to jump in, and also if you are not on the panel but you have a question, just put your hand up. The hand up is in the reactions thing where it says raise hand. So if you have a question and you'd like to jump in, just pop your hand up and I will keep the queue. So I find this this particular case really, really interesting, and also provocative, but provocative in ways that at first seem sui generis. But then the question is, to what extent is this a general, are they generalizable? I mean, the behavior of Russia in connection with this particular loan seems distinctly political at all steps of the initiation of the loan, the way, and then the creation of the manufacturing of the default and everything else. But if you take it out of the, and by the way, they should lose any lawsuit that they end up in as a result of that kind of behavior, and a legal system that doesn't take that into account is weird. But the question is this a, more generally speaking, a problem or a feature or just something general? And we also think about the fact that China owns tremendous amounts of US sovereign debt. And we sometimes think that's bad because it gives them control over us. And we sometimes think maybe it's good because maybe they don't want to wreck our economy because they've got so much value parked in it. So there's a relation to the extent that this happens, it can go both ways. It can be power giving, but it can also be relational in the sense that it gives everybody an interest in everything else, and a move towards a certain amount of sovereign independence, interdependency that might actually be a good thing for global governance. So that's sort of thought number one. Thought number two is the interaction between this kind of behavior and Adam may want to jump in on this. I just kept thinking about the odious debt problem, which is sort of the flip side of, we generally don't care about the behavior of the obligor on the debt, or the reason that they entered into the debt. We don't want that to affect the payability, otherwise debt markets won't function. So those are sort of two different sides of it, which is what are a little bit about what the general lessons of this are. Not sure if that was coherent, but
Is Odette got her hand up, I think, Ted?
Odette does. Okay, so yeah, well, let's collect questions and then we'll let Jay. So Odette?
Sure. Do you want my video on? I wasn't sure what the video policy was, but
I think the video policy is, if you're speaking, you should definitely turn your video on. I think we when we were all talking, I think it made sense to have the videos off. Now that we're all just in the room together, why doesn't everyone who wants to turn their video on, and we'll see if it tests the bandwidth.
Odette, good to see you.
Hi, Jay. Nice to see you. So Ed, thanks for that really interesting discussion and the paper. And I sort of remembered this from a while ago when it first came up. And then, you know, you're absolutely right. Given everything that's going on. It's sort of surprising that this hasn't been discussed more fully. So this is fantastic. My question was really, I guess, a follow-up to Ted's, because I was curious about your thoughts on the odious debt doctrine, right? Because that has been understood as an effort to present a set of principles that actually would apply in a really small number of cases, actually, given the sort of double-pronged nature of it, and how it might apply to something like this. And then also just a suggestion to look at Anna's paper from back in the day, Odious Not Debt, right? Where she is quite explicitly talking about some of this stuff, because it seems like that might help, just encourage more thinking about broader principles and when they might apply and not apply. So anyway, but this is really interesting and such a nice presentation of all of that material that's happening in Ukraine, Russia right now. So thank you.
Thank you.
Adam?
So I was going to defer to Odette on odious debt and cite Anna's paper that Odette cited as well. So thanks for doing that. And Odette, it's great to see you as well as everyone else here. I actually had a question on the not debt part of Jay's project, and it's actually kind of a narrow question. And I don't assume that you would know, but I'm interested in the question of how performance under this arrangement, let's call it a loan, would be subject to cross default provisions in commercial loans. So it may not be justiciable, but it seems like Russia and China's of the world could wreak havoc if these were subject to cross default provisions. So I just actually don't know whether cross default provisions would include these kind of sovereign to sovereign loans, and if so, whether them being treated as kind of non-justiciable might intervene in the application of those. Again, this is kind of beyond the scope of your project, but it's something that occurred to me, and I'm curious.
And I guess the last person in the queue is John, and then we'll let Jay jump in with his thoughts. John?
Okay, let's see. I got a little bit late. Hi. The non-justiciability point, Jay, is interesting because usually we think of that as a judicial humility doctrine out of comparative institutional competence, right? Saying we're not going to wade into this because it's really a political question, and we're not going to do that. Now, what I take as the alternative holding, and I guess I'll ask Jay to expand it because he's more familiar with the judgment than I am, is it's a little bit more than that. It's not a humility thing. It's almost like a finger wagging, which is, listen, if you want to, play in this sandbox for whatever reasons, for straight up debt collection purposes or for exercising political soft power or whatever, then you don't get to sort of try to have your political cake and eat it too. And so I see that as possibly a muscular assertion of the judiciary and the rule of law, and using, strangely, the non-justiciability doctrine to exercise that influence. So I just want to get a reaction from Jay if I have that right, or if not, for him to correct it. Oh, yeah. Cheers.
Great. And we have one more question from Barry Herman, and then I'll let Jay get in. And then we need to let Jay get in so that we can stay on time.
Yeah, okay, thank you. This will be quick. I was thinking back to the SDRM proposal at the IMF, and originally it included the Paris Club as creditors who would be brought into the discussions about debt relief. And of course, the Paris Club governments decided, no, they didn't want to be part of this. And of course, the whole thing died. So I was just thinking, from this discussion, is there some way to bring private and public creditors to the same table? Well, we've always thought of different tables. Is there a way to bring them to the same table? Thank you.
That is a terrific question. They're all good questions. Let me just I only have a little time, so let me just address each one of them quickly. Ted, your comment about is this a one-off or does it extend to other things? I think it extends potentially to other things. What leaps to mind is the Chinese initiative, the Bridge and Road Initiative, which I think may very well put the Chinese in a position of deciding whether or not in a particular case they want to use a certain kind of enforcement device. Public enforcement devices are awkward and they don't work very well. And well, gee, go see the Paris Club. Well, I think perhaps Russia in this case didn't find it very attractive to go sit down with a bunch of other countries that don't always like it very much and might not work with it and might not help in its negotiations. This is an alternative to dealing with the Paris Club or even the IMF, it seems to me, and therefore quite possibly may be tried by others as well, depending on this one, how this one comes out. I agree, Odette, that odious debt is certainly a concept that leaps to mind in the context of this situation, but that involves an awful lot of proof. It seems to me it's much simpler to say, hey, this guy's on my border shooting artillery into my sovereign country, and that's enough for duress. And whether or not we go back and we find out it was odious debt, I don't know. Although there's a real, sometime you and I could talk offline about that, because there's a real overlap between the notion that the promissory note itself was the product of unreasonable pressure. But that's a little bit different from saying it had a bad purpose, right, or a bad use. Anyway, very much interrelated and very much worth thinking about. Adam, the cross default thing is fascinating. I frankly hadn't thought of it. And I don't know how that, I have absolutely not thought about how that plays out. The only comment that I make here is that the need for intervene in the one default as a matter of its political status. But I have not thought about the cross default thing, and I now will. So thank you very much. John, I think you're right. I think the Court of Appeals was being aggressive in saying this is a non-justiciable cause of action. But they also did it in the alternative, right? If you just want to sue on an ordinary commercial note, I think that the British courts are very sensitive. And there's been a little bit of commentary on this from some British lawyers. We don't want to look as if we don't enforce everything strictly, because that's why everybody comes to England to enforce their commercial obligations, because we're tough guys and we enforce whatever you agreed to. So I think that the Court of Appeals was careful to say, you know, you can enforce this note here, but you can't have it both ways. And I think Ted was quite right in identifying that as a key point. And finally, Barry's point is also very interesting. I think that Russia may well have wanted to avoid the Paris Club completely for the reasons I indicated. And for that reason, I think it's not unlikely that this sort of thing will come up again. Whether or not you can sit down countries with their various political concerns and private creditors, I don't know. But I thought that the initiative in 2001 was a very valid first step for all of its serious flaws, which I had occasion to point out at the time. And I think we really need to get back to it, and the need to get everybody around a table, even though they have very different kinds of interests, is right at the heart of that discussion. So thank you, everybody.
Thank you, Jay. This was really great. That half hour went by really, really fast. So for our next paper, we're jumping from all of these papers, and this is the brilliance of sovereign debt, is it pushes us private law people to suddenly think about not just the political, but also the systemic effects of debt and the way in which debt markets react to systemic shocks. And Winnie Tarnier-Bakary-Kiriou-Abouere has written a really interesting paper that gives us a look, both, which I found really interesting, both because it gives an insight into the Ugandan banking system, but also lets us see how the shock of COVID affects the overall banking system at a systemic level. That's probably, I won't give away any more of your paper. I will turn it over to Winnie. Take it away.
Thank you. Thank you. Okay, sorry, I was struggling to unmute, and I hope you can see.
Yeah, we can see that the slides are up.
Okay, good. Thank you, Ted, and thank you, III and everybody for organizing this. And so my paper is basically an analysis of the impact of COVID-19 on financial institutions and looking at the policy measures that were put in place by the central bank to try and address the challenges of COVID-19 on commercial banks in Uganda. And so we are all familiar. I won't spend a lot of time on this the impact of COVID-19 at a global level and also at the individual countries. Just a little bit of information on Uganda. We have various categories of financial institutions, but the formal financial sector is dominated by commercial banks. We have currently 25 commercial banks with 566 branches. Commercial bank lending as of 2019, that's prior to COVID, at 14.5 trillion shillings. Commercial bank assets at 32.8 trillion shillings. All indicators showing that the commercial banks were stable and resilient, well capitalized, able to absorb any potential shocks. If you look at the commercial bank lending, the distribution of commercial bank credit is largely in these 5 sectors: agriculture, manufacturing, trade and commerce, real estate and construction, and personal and household loans. The bulk is in trade and commerce and real estate and construction. And these were some of the sectors that were hard hit by the COVID-19 pandemic. And so here at the start of the pandemic, we had some sort of projection on how long the sectors would take to recover from the pandemic. Of course, we initially thought the pandemic would go away very quickly. And so some of the sectors I've talked about in the previous slide, like manufacturing, agriculture, were expected to recover in the first year. Building, construction, trade and commerce expected to recover within 2 years, and then commercial real estate perhaps in over 2 years. That changed as the COVID situation stayed around a little bit longer. And so we continue to see, for example, construction beyond the 2 years still struggling to recover, as well as commercial real estate. Now, the start of the pandemic, the Bank of Uganda announced some policy measures for commercial banks. And the measures had 3 objectives. 1, to enable continuity of operations of commercial banks. And secondly, to allow stability of financial institutions. And the third was, of course, to enable credit support to continue to support the real economy. And my analysis focuses on the last 2, the stability and the issue of credit support. The measures were wide-ranging, including emergency liquidity support to commercial banks, capital preservation measures, loan repayment moratoriums, and then the last ones were really about continuity of operations, use of digital platforms, and operational health and safety measures. The very last one on loan-to-value limit of 85% was specifically within the real estate sector. These measures were not very different from measures that were introduced in other jurisdictions, where we saw release of buffers and other capital requirements, payout restrictions, which were essentially capital preservation measures, and liquidity support, and so on. So we ended up having, with these measures, and in a situation where The bulk of commercial bank loans, this is in relation to the credit relief measures, about 7.1 trillion loans were restructured. And 2 years after COVID, we still have about 3.1 trillion loans. That is about 16.7% of industry loans under restructure. And the sectors that have continued to struggle are also, the measures have remained in place, although these have been lifted as the economy has opened up. The major restructures were concentrated in construction, real estate, trade and commerce, agriculture and manufacturing. We had the highest, Uganda had the highest restructures in the region, and that has also raised issues of concern for the stability of commercial banks in Uganda. So in assessing the impact of the COVID and how these structures, these measures were able to allow financial institutions to remain stable, I will focus on issues such as capital adequacy, funding and liquidity, credit performance, earnings of commercial banks, and the performance of the large commercial banks. So what we see here is that in terms of capital, pre-pandemic, and here I show from 2010 to 2021, the commercial banks were well capitalized, and that is why at the start I said they were in a comfortable capital position and able to absorb shocks. The red line shows the capital requirement for Tier 1 capital for commercial banks. It was raised in 2018, and still commercial banks were way above the requirements. So you can see that in 2020 as well as 2021, that despite the COVID pandemic, the commercial banks remained in a comfortable capital position. When we look at Tier 2 capital requirements for commercial banks, again, it is the same story. No issue to worry about as far as the capital position is concerned. On the liquidity issue, the gray line at the bottom is the regulatory requirement of 20%. Again, we see that throughout the pandemic, the commercial banks, that was 2020, 2021, commercial banks are in a comfortable liquidity position. Another liquidity measure that is used for commercial banks is the liquidity coverage ratio. Again, we see, which is supposed to be at 100%, right from 2016 and through to 2021, we see that commercial banks are highly liquid and no issues of concern. When you look at the earnings and profitability, again, the trend for 2020 and 2021, which were really the tough COVID years, you see that the earnings, there's nothing unusual from the previous trends, at least the years before the COVID pandemic. However, when we get to issues of asset quality, we see that if you look at the years before 2020, that is, let's say starting at 2016 is unique. We had an election, and so everything went out of the norm. But if you look at 2017, 2018, the non-performing loans start to come down, and then they start to go up in 2019, and they continue to go up in 2020 and 2021. And this has been an issue of concern, and that has an impact on whether actually the commercial banks are able to continue providing credit going forward, and their long-term stability also going forward. If you look at this trend, and it starts to show the problems that I want to talk about, and this is a graph on private sector credit, starting from July 2019 up to April 2021. So we see that although we have the measures in place and the commercial banks were in a good capital position, lending is on a declining trend. And therefore, the ability of commercial banks to continue supporting economic activity is sort of challenged. And we may see this trend continuing because of the rising NPLs that I just talked about in the previous slide. What we are also seeing is that increasingly commercial banks, because they are now risk averse, we see less lending and increased exposure to government securities. And therefore, the early objective I talked about of the measures being able to support commercial bank provision of credit to the economy, that may not entirely be achieved going forward. because of the risks that now the commercial banks sit with. Sorry, that is the same graph, just showing the increasing trend of commercial banks to exposure to government securities. That raises issues of concern because we have seen that in 2020, I mean, since the COVID-19 pandemic, there's been an increase in the fiscal deficit. Debt to GDP is over 50% in the country. And therefore, there are questions around the sustainability of public debt and potential risks to the commercial banking sector as the commercial banks slow down on lending to the private sector and opt to invest in government securities. So so at the end of the day, what I'm trying to say is that although we had a situation pre-pandemic where we had, the commercial banks were in a pretty stable position, the measures that were put in place to deal with the COVID impact had sort of a muted or a temporary impact on stability. We see potential threats coming up, particularly from the rising NPLs, reduction in the private sector, the trend in private sector credit, showing the potential risks lying ahead and therefore reduction in lending. But because the commercial banks are not lending, they are diverting that to government securities, and therefore the increasing exposure to government in a situation where we are concerned about government debt and the ability of government to meet its obligations in the future is a real issue of concern, and I think may contribute significantly to concerns around stability of these financial institutions. Interestingly, even with the non-performing loans, we see data that shows about 5% of the non-performing loans are actually loans that are linked to government arrears, inability of government to meet its obligations, particularly in some of the difficult sectors like construction sector, where most of the projects are funded out of government. And so those are some of the key issues of concerns and potential impact on the commercial banking sector. And as if that was not enough, of course, we've seen slow recovery of some of the key sectors where commercial banks have historically provided credit, the construction, as I mentioned, real estate, but also the challenge that everybody is talking about globally, issues like inflation, and that will also come back to impact cost of credit, and ultimately we cycle back to the problems that I have talked about earlier. So that's what I intended to talk about. I'm happy to stop here and take some questions. Thank you very much.
Great. So I'll ask a first question, and if others have questions, pop your hands up. What an interesting paper. I guess what I end up wondering about, and this is one of those things where the story you're telling suggests this, but I don't know if it demonstrates it, which is, so the good story is that the banking sector in Uganda is in good shape, had adequate capital to go into the crisis and weather the crisis well. That the government interventions have again preserved the health of the banking sector, but the result, but the attendant thing is that loans going out into the regular economy are down, and so it raises the question of, is there? I mean, or maybe you could say a little bit more about the relative effect of COVID on the banking sector versus its effect, the banking sector's response, and the extent to which the relief measures have had effects on the regular economy.
Okay, so I would have to, let me see, go back to this slide and maybe this one where I mentioned the sectors. Most of these sectors that I talked about were the sectors that where the commercial banking credit is heavily concentrated: agriculture, manufacturing, trade and commerce, real estate and construction, personal and household. And all these were impacted by the COVID sector. Without the measures, we would have seen difficulty in repayments, huge NPLs, which would then mean that it would have to impact commercial banks' capital. They would be required to put up additional capital because of these NPLs, and perhaps some of them would enter into some degree of difficulty. So with the measures in place, what it meant that this impact was stemmed. In other words, the non-performing facilities were restructured, which means that the commercial banks did not have to provision for the non-performing loans, and that did not then impact their capital position. So in other words, the measures they simply provided a stop to a rundown, if I may put it that way, of a significant deterioration in the credit portfolios, which would have significantly impacted the capital position of banks. So it was some kind of temporary measure, because as the economy opened, the measures came to an end. We now see the heat starting to take place. And then we start to see questions on long-term stability of these institutions, because some of these sectors have not recovered, and commercial banks, and we now see rising NPLs, but we also see that commercial banks are not willing to lend and diverting, instead opting to invest in government securities, which increases exposure to also an area where we have concerns about debt sustainability in the public sector.
So, oops, I'll ask another question. So one of the things that you talk about, Adam, go ahead, jump in. I've got another question, but well,
I didn't mean to.
No, that's okay. I'll save my question. We'll let others. Great.
So I'm, interested in, again, this is kind of beyond the scope of the paper, but towards the end, you note the kind of current and coming situation of kind of global slowdown and inflation, and I'm curious, what your guess or speculation is about how this discussion 5 years from now will be similar or different to your findings with respect to the COVID crisis, whether you expect the country to, in the banking system to fare as well, whether this represents a greater threat on the horizon, and I guess related to that, I'm always, global conditions affect every country differently, and so I'm just curious if you have a sense of what are the pathways to affecting Ugandan economy from a slowdown globally and inflation elsewhere in the world.
Yeah, I mean, that's kind of difficult, because I don't think we can shield the economy from that. The sad thing is that, of course, because of the current economic circumstances, we are starting to see interest rates go up. And that complicates the situation, because it's going to increase the cost of credit, also increase perhaps potential defaults. And what we will then see is a limited one role of the banking sector, which I started off by saying that the economy is dominated by the banking sector. That's the major source of private sector credit. And so we will see a limited role of banks in supporting economic activity. But we also faced with a situation where we don't have perhaps the correct measures to deal with these rising NPLs that banks sit with. The question is, what do you do with them? We have limited frameworks or tools for dealing with this. We have tried before when we've had our own crisis. You create a specialized entity. We did it, didn't quite work to handle those. And so there are questions of what do you do with these assets, bad assets that banks are sitting with, but also in a situation where the economic circumstances are continuing to deteriorate for the banking sector.
Anna?
Hi, folks. I'm still going to be off camera because we're still attending to the tax-law emergency, but I really found this presentation fascinating and very valuable in the broader context of kind of bank-government interactions during the pandemic, because what we've seen has been a huge spike in government debt, but in particular in low and middle income countries, a really, really huge spike in government debt on the balance sheets of domestic banks, which is not surprising, but important nonetheless. And up until recently, the conversation about the so-called doom loop, so the link between governments and banks, if banks go down, governments bail them out, then the government debt becomes unsustainable, but then that in turn brings down the banks, et cetera, et cetera. That has really been very much a European conversation. And I'm wondering, Winnie, whether you have any thoughts on how kind of doom loop vulnerabilities might play out, first of all, in a banking system like Uganda's, and then also in an inflationary environment, right? I think those two things are quite new and haven't really been discussed. So I'd love to get your sense of that.
Yeah, I think I had the bit about the inflationary system. What was the first one? Sorry.
The doom loop, right? So basically what happens when, either in a government debt crisis or in a banking crisis, we have seen governments place a bunch of debt in their domestic banks. But then what happens is the banks and the governments become incredibly interdependent, so that when the government sneezes, the banking sector catches the flu, and vice versa, right? And it raises all kinds of financial stability concerns, but also affects the government's ability to pursue macroeconomic policies, et cetera, et cetera. And in a world where the tools are already stressed because of high global interest rates, commodity shortages, et cetera, right? That could be a really bad dynamic. But I've only seen that discussed in Europe because, you have Ireland with banking sector 5 times the size of its GDP, that sort of thing, right? I haven't seen this discussed in Africa or elsewhere, but the IMF financial the GFSR, the Global Financial Stability Report, has been banging on about this for a while, but I haven't seen it discussed in Africa. That's why I thought that the point in your paper and your presentation about government debt in the banking sector is phenomenally important and interesting. So what are the vulnerabilities that come out of having a bunch of government debt in the banking sector, apart from less lending to the private sector?
Okay, so the issue, of course, we've had it, and maybe I should move to this and one of the slides where I show government debt compared to private sector lending is that, in prior years, it was perhaps about 40%, maybe close to 50%. And it was known that, that's sort of the trend, and lots of conversations around reducing that and governments crowding out the private sector, but no real interventions. The challenge now is that we are in a situation where, because of the challenges brought on by COVID, everybody's talking about the issue of the rising debt of government, because government needed to put in place interventions to deal with these problems. And now we sort of don't have the answers to the questions, because government continues to borrow. The conversations around the sustainability of government debt are there, but then also the economic circumstances. So previously, if you didn't have some of these factors play out, it sort of tended to I won't say automatically reverse itself, but as the economy stabilizes, then you see banks have confidence to continue lending to the private sector, and then you sort of reduce the government debt holding. Not significantly, but you tend to see increases in private sector activity by the banks. The situation, the challenge now is that the economic circumstances are not leading us into that direction, and so we don't know how to deal with the problem now. We sort of sit with watching this play out in a very concerning manner. Thank you.
Great. And for the last question, Jay.
This is really a thought-provoking paper for me, Winnie. Thank you very much for it. It strikes me that this whole phenomenon you're talking about really must exist in a lot of banks around the world. Not necessarily non-performing loans, although certainly that, but also many other things, moratoria that have been declared during the COVID emergency that now are ending, and people are getting evicted, for example. That's in the newspapers every day, who were able to hang on for a long time and who ran up very substantial rental bills in the process. One thinks of all the students who were able to stop paying on their student loans, and now payment is demanded again. So I wonder, your paper makes me wonder if there aren't a lot of banks and others who have a lot of built up danger in these sorts of measures that were taken on a temporary basis during COVID.
Yes, and I think in a lot of jurisdictions, you see that it was expected that once the measures are lifted, you'll start to see the impact on the banks. However, the assumption had been that the economy would, as the economy activity picks up, that then everything starts to normalize. That was the assumption. That is not working in that direction. And I think that's the complication that comes into this.
This brings us to the end of our time, but it actually reminds me of a conversation that Rich Levin and Don Bernstein and I were all teaching a class together on systemic risk in March 16th of 2020. It was the last class I taught before we went remote. And we were discussing what we then thought was going to be a short-lived crisis, but one that would certainly have systemic effects. And what seemed to come out of the conversation was the view that there was going to be a fair amount of pain at the ground level, which didn't actually happen because of that would then get pushed up into the banking system, and that ultimately you would end up dealing with the COVID hole or in the economy by relieving the banking sector. And what we've seen instead is maybe we will see that, but for almost 2.5 years out, it's been a very slow motion train wreck as relief was given on the ground and to the banking sector. And we're only just now beginning to see what we'll call the systemic effects in the banking system, with the exposure to government debt and the non-performing loans beginning to show up, which is that we continue to feel, I don't know if this is a cartoon that was broadcast in countries other than the United States, but the Roadrunner, where Wile E. Coyote runs off a cliff. And the rules of the cartoon strip is he doesn't fall into the canyon until he looks down. And what we're seeing is that the banking system has weathered it, but we still don't know what the systemic effects are going to be as this plays through the system. And really, really interesting and really, really helpful. So for our next and last paper, I think we return to the theme of the relationship between public debt and private debt resolution institutions with Adam Feibelman's paper on municipal debt in India. Adam.
Super. I'm, for some reason, having trouble.
Do you want me to share your slides?
Yeah.
You just sent them to me, right?
Yeah.
I can, if you give it one more shot, and if you can't, I can do it.
I think the problem is on my side.
Let me just make sure that I've made you co-host. No, it's on my side. There, now you should be able to do it. Give it one more try. I just changed a setting.
Well, for some reason, it's just not showing up on my, when I'm trying to share.
Here, while you're doing that, I will.
Yeah, I'm sorry.
No problem at all. Let me, here, I got it. I can do it. Wait, that's this one. There.
Super. All
okay.
Right.
Just tell me when to tell me when to switch.
Okay. So first, thanks to DebtCon and III for including the paper. I'm sorry my co-author Bhargavi can't join. She's a super lawyer and scholar based in Mumbai who's getting her SJD in Singapore now. You can move to the next. Thanks. Just as a roadmap, I'll talk a bit about the kind of nascent market for municipal bonds in India, talk about the legal framework for the market and for default, the very minimal legal framework, talk about Chapter 9 in the US as a potential model, not because we think that anything like this is about to be adopted, but really as an exercise, as it says here, to identify issues and challenges. And if you could move to the next. And since there's a danger of this seeming like a paper in search of a problem, I just wanted to say a little bit kind of about some of the kind of deeper motivations. One is just this question, which I find interesting and have dealt with in other contexts, on kind of the sequencing of adopting a bankruptcy, kind of bankruptcy as a development tool in relation to market development. And as we see, it's usually adopted when it's needed and rarely before, but it's still, I think, useful to debate the possible reforms, bankruptcy type reforms, partly for academic, in the best sense of the term, reasons, just kind of to understand the need and the dynamics at play. But also, I think it can serve a practical function of identifying more modest and potential reforms. And in any event, looking at this topic of municipal finance, municipal debt in India has been a really interesting window into the financial and structural relationships between levels of government there, and in particular on constraints on municipal finance in the country. Yeah, thanks. This is a really important set of issues against the backdrop of rather dramatic urbanization in India recently and projected. The UN has projected that by 2050 there could be an increase of 400 million in the urban population, which would be more than the US population. So this is, these questions impact huge numbers of people in where they live. Thanks. So just a little bit about municipalities, kind of their status and functions. As the paper discusses, in the 90s, the country had basically adopted a constitutional framework for local government and representation in local bodies. So there's this constitutional framework for local government, but the responsibilities and powers of municipalities are still matters for the states, and are set forth in state laws throughout the country. In general, municipalities have very kind of scarce resources and revenues. I think for the most part, the revenues come in the form of property taxes. There are some other sources, but that's really the main source of revenues. And the ability to collect property taxes is limited in significant ways by the capacity of the taxing authorities at the municipal level. There's a very significant reliance, heavy reliance on intergovernmental transfers, which are sizable, but I think generally understood to be less than needed to fund fully what needs to be, kind of done at the municipal level. Can you?
I'll go back. Sorry, I jumped in.
No, I'm sorry. I didn't notice that you had changed it.
Oh no, okay, there you go.
Yeah. Thanks. So against that backdrop, there has been, interestingly, a meaningful development of a market for municipal bonds in India, although quite small and still nascent. The very first was in 1997, and there was kind of slow trickle after that, and then picked up in around 2017. I think it's fair to say, with the encouragement of the union level government, which is an interesting theme, I think, that I'll touch upon a little bit more. But every national government has had goals of with respect to urban policy, but is limited in the levers that they can use to actually affect governance and development at the local level. So I think this is an interesting example of encouraging the issuing of municipal bonds. So there have been 9 issuances, as far as we know, since 2017. Not large numbers, about $500 million raised. We're still kind of pouring through these. It's actually quite opaque, the process of kind of learning about these issuances, but generally they're unsecured, but have features that kind of structure payments. So in the paper, we discuss the bond issued by Pune, which is kind of developing into a bit of a case study for us, I think. Pune is the second largest city in the state of Maharashtra, behind Mumbai. And its bond was unsecured, but the way it was structured was that property taxes, as far as I can tell, all property taxes were paid into an escrow account for the bond. The bond debenture trustee has a lien on that account, and then any surplus is then returned to the city. So property taxes go first to the escrow account, and then if there's surpluses to the city. Some of these bonds are non-taxable, but not all, and there's not a blanket rule for that. It's a bit complicated whether they're taxable or not. There are interesting limits on subscription, who can purchase these bonds, and limits on the extent to which foreign portfolio investors can, and the amount that investors have to purchase, which I think combined basically mean that most investors or purchase of these bonds are domestic and institutional, and are entities that the government has significant authority and power and leverage over, in the case of anything going sour. So to the extent that there's a legal framework for these bonds, it basically, there are kind of a few kind of elements. There are securities regulation, which is basically ex ante. There are eligibility criteria for which municipalities can issue these bonds, requirements for credit ratings. There are state laws that control taxation and borrowing. So the Pune bond, for example, the city had the power to do it, but first needed express state authorization to issue the bond, which it received. And I'm not frankly sure what the process is for the state granting authority, but there's a letter in the record from the state officials authorizing it. So the legal framework is basically, to a large extent, in the bonds themselves. The structured payment mechanisms, various covenants. The Pune bond, for example, has a covenant on future borrowings, the ratio basically of how much borrowing the city can do, limits on subscription, the creation of a debenture trustee. These kinds of things are kind of bond specific, and basically what I think is fair to say, largely the extent of the legal framework, which is then subject presumably to enforcement in the general legal system, which is definitely untested in this context. Next slide.
Got it. There we go.
Thanks. So it's I think useful to at least think, well, what happens if there is insolvency? And I think it's important. I didn't really add this to the slides, and that we don't discuss in the paper, but it's also important to understand that state finances are in a precarious situation now as well. So there is a possibility, if a municipality really got into financial distress, that there would be a bailout from the state or the central government. But I think that would be tricky and delicate. So there could certainly be, and we've seen this already, kind of preferential treatment among creditors and potential for selective defaults or IOUs, delays in payment, that kind of thing. And so I think we should at least assume that there's the possibility of losses to be imposed, at least on some stakeholders, which creates, inevitably tensions among them. And our, part of our motivation is the belief that this uncertainty about how things would play out imposes costs on the cities, on the development of a market for municipal finance and their ability to tap capital markets, and represents a risk for vulnerable stakeholders, especially citizens in the municipalities. And so we, kind of imagine what a bankruptcy regime for municipalities would look like. And it's unlikely, again, that this, I think, is going to happen, but it's not, fantastical. This is against the backdrop of recent adoption of a very comprehensive new corporate bankruptcy regime that I think has its problems, but is generally viewed to be, I think, a successful legal development in the country. And so I think that the society is at least primed to take bankruptcy more seriously as a tool than it would have been even 5 years ago. Sorry, Ted, thanks. So for this group, I'm not gonna, we've talked about Chapter 9 a little bit, but in thinking about, the kind of translation, it's useful just to kind of note a few of the basic aspects, right? It's in the US, it's a federal law, but involves state control, at least in important respects. There's a significant eligibility hurdle for municipalities that want to use it. The debtor files in the US with state authorization, but this is would be quite different than the kind of insolvency regime that India has adopted, which relies primarily on creditor initiation. Chapter 9 is court managed, but the court has very limited, certainly no formal power to affect government functions, is generally negotiated in meaningful ways, but rule bound with respect to things like protections for classes of creditors. In thinking about how a regime would be translated in India, there would be these kind of practical questions of institutional design. What would be kind of eligibility criteria? Who would trigger it? Again, the idea of creditors triggering in the municipal debtor context is a bit more difficult to envision. How would plans be developed and adopted? And what would be the judicial or administrative function? This is actually, I think, one of the more interesting questions, because the corporate insolvency regime is run by tribunals, company law tribunals, which presumably would not be, I think, the right venue for a municipal bankruptcy, although I'm not exactly sure. So I think there may need to be thought of about creating a particular a unique venue and administrative or judicial institution for this. And the interesting deeper questions would be how a system would balance powers among levels of government, especially kind of as between the union level and the state governments, and what impact it would have on its operation would have on private stakeholders, and just the realities of political economy, how feasible it would be to adopt various design choices. I think I have one more slide. Yeah. Just kind of moving forward, is there a present problem? We think there are costs to the uncertainty, but reforms tend to follow crises. Hopefully this can this kind of work can inform debates and discussions that may frankly be a bit further down the road. So I think I'll stop there and just say this is a very early stage in this project, and we're very eager for feedback and suggestions on directions to go, or topics that we should explore. Thanks, Ted, so much for managing those slides.
No, that was fine. That was fun. I really like this. I mean, the papers on this panel, I just keep learning stuff from, and just getting a window on another country's system for dealing with municipal is so valuable. One thing, and I find one of the most interesting things about doing comparative work is to sort of see how the things that you're doing in your own country map onto, or might map onto, something in another country. And I sort of wanted to sort of think about the Chapter 9 analogy and wonder, I mean, so the Chapter 9 in the US, on the one hand, rises and falls on the fact that we've got a relatively strong, sophisticated, pragmatic, common law set of bankruptcy judges who have legitimacy within the system. On top of that, with all of that, Chapter 9 is actually a relatively weak, non-compulsory structure, except for the moratorium. It doesn't actually impose that much discipline on the debtor, nor does it impose that much compulsion on the creditors. It ends up being we have this idea that it's bankruptcy, but it's really sort of a beefed up mediation system in a bankruptcy court. Which raises the question, once you move outside of the US to a system where you don't necessarily have a well-developed, highly legitimate set of specialist bankruptcy courts, is bankruptcy court necessarily the institution that you would want to use in order to structure the debt resolution regime. And then once you ask that question, you ask the next question, which is what are the functional attributes of what Chapter 9 is actually doing? I mean, in particular, one thing that would tend to happen in non-US countries if you created a Chapter 9 would be the creation of they tend to be fiduciary driven. And so if you have a public fiduciary, then what you end up with is receiverships, which you probably don't want, right? And so what I'm wondering is whether it would be worth thinking about obviously you can run the way New York City did in the 70s and just it becomes like sovereign debt. You figure things out as you go along and you do it with no structure. But to what extent would a country with a weaker bankruptcy court system could they do in order to create rescue regimes for municipalities? I don't know if that requires a question. It's just sort of a thought that was provoked by your paper.
Yeah, so just quickly, because I kind of rushed through this a little bit to not take up too much time, but you know, what I was hinting at is that the development of the corporate insolvency regime there really has improved the capacity of the judicial system there to do this kind of thing, and I think it's fair to say that the judges on the tribunals are you know, have a decent degree of respect and legitimacy. So you know, whether structurally, I'm not sure a company law tribunal would work, but the judges on the tribunals could themselves be a pool for doing this. And I mean, I think it's, you know, that may be one of the surmountable hurdles to coming up with a formal scheme. But I'm not entirely sure. I do think that if this were going to be run through the regular court system, then people would have great concerns, just because that's proven to be a very slow and messy system, and that the tribunals were created to avoid.
Yeah, you know, that was my impression of the Indian bank, the formal bankruptcy structure in India.
Yeah.
So we've got a question in the chat from Greg Makoff. How much of the Indian muni bond paper is owned by state-owned banks? If it's a high percentage, would that suggest a state control mechanism might be favored when it comes to local legislation?
Yeah. So one challenge, one of the many challenges of doing this project is it's very, very difficult to figure out who owns these bonds. So they're private. Many of them private placements. But I do think, and this is kind of our next step of trying to figure out how much we can discern about, you know, who are some of the investors. I think we should assume that the banks are, you know, own some of this paper, but I'm not sure whether the state-owned banks or private banks. And I do think that there are, you know, investors that are not banks that are buying this paper. So I don't know what if it is. You know, once we assume that it's not exclusively or even predominantly state-owned banks, then, you know, I think your question touches on, you know, a really important question about whether we think a state control mechanism or not would be needed. I don't know if that, you know, I'm happy to follow up.
So I think this brings us to, Odette. Okay, for the last, we're getting close to the end, but then I don't think they turn off the Zoom. So Odette.
Hi, Adam.
Hey.
This is so great, and just learned a ton. And I was curious about the degree of variation across municipalities? I mean, part of it is you just are lacking the data, which you just said. But it strikes me that within India, as compared to other federal systems, there's really significant variation in the internal kind of political makeup, economic makeup, all of that. And I wonder if you had a chance to sort of speak to some of the managers on the ground in the municipalities and get a sense of their view on this, because my guess is maybe they would have very different views, but I don't know. And I just wondered if you could speak to that a little bit.
Yeah, so first of all, there is huge variation. And actually, state by state, there's a lot of variation on just the basic legal framework for what municipalities are allowed and to do and what they're responsible for doing and how they're supposed to do it. So, whether they can borrow at all and under what circumstances. And so, yes, a lot of variation. So I think, what's interesting in seeing the development of a market for municipal bonds, of issued by cities across the country, is that at least from that kind of radical heterogeneity, there is some kind of uniformity developing, and so I think that might be part of what could be appealing about a union level legal framework for financial distress to help kind of steer the uniformity. I don't think that's how it's going to play out. But I in an ideal world, I think that could be a beneficial function. But I would love to, I haven't been able to go since the pandemic. And my co-authors who are there, I think we're really struggling now to figure out. There are people there who will know the answers to, there are people that work in the institutions that are issuing this, or in the municipalities, and I think that's the next stage in the project, is to try to figure out who really is in a position to answer some of these questions that are and provide information that's not publicly available.
Well, super. I think this brings us to the end of our allotted time. I think I'll give it over to Anna for a last word on DebtCon, but I'll take a last word on this panel, which is, I can't believe how much I've learned today, both from David and from each of the three paper presenters. I do, one of the nice things about having a triple I panel is we really do come over from the private side to the public side, and it feels like a trip abroad that just gets a whole bunch of different sets of juices flowing, and I've really taken a lot out of it. I hope everyone else has as well. And I'm hoping that next, as we say at the end of Passover, next year in person. Anna, do you want to take a couple closing words?
Ted, it's what Ted said, everybody. I think juices flowing is a great note to end on, and flowing until next year. I too have learned a tremendous amount, saxophone emergency notwithstanding, and
new frontiers in multitasking. That was amazing.
Well, it helps when the emergency is driving. So, it's one advantage of 16-year-olds. Just thanks a million, everybody. I learned a tremendous amount, which is saying a lot, because I was sitting next to a driving child. And I can't wait to see you all in person. Thanks a million to Triple I. Thank you to EUI, to the Graduate Institute, to the Sovereign Debt Forum, and of course, Georgetown Institute of International Economic Law. Everybody, it really does take many, many villages to put this together. So come with us, stay with us, hang out with us, and let the juices flow. Thanks a million. Oh, wait. Sherry, yeah. Thank you so much.
Oh, yeah, actually.
Oh, duh, yeah. Right?
Right.
Just, we would be nowhere without Sherry, who made this possible despite all of our ineptitudes. And I think Iman might still be on the phone, who really helped on the Georgetown side. And never enough thanks to Margarita Fabri in particular at EUI. So that's it. We owe you everything, and we hope we haven't messed up your work too much.
And thank you all for the wonderful papers. The great thing about putting something like this together with smart people is that you don't have to be smart yourself. You just have to bask in the reflected glow. So thank you. And thank you, Sherry, right? Is that what you were pointing at? I can't tell. Yeah. Yeah. Thank you, Sherry. You make us all look good. So thank you again so much. And thank you all for coming.